My name is Emily Neal. I run a program called HLS Beyond out of the library. And we bring together people in slightly lower stakes environments to learn skills, learn new ideas, talk about current events, which can be run by students, faculty, or staff. So if any of you ever have an idea for something you'd like to turn into an event, please find me. There are signs all over. You can scan and find HLS Beyond on our website, so you kind of know what the deal with the stuff that we do is. That's all I have to say for me. I'm going to turn it over to Jay-Z, who's going to introduce you to our panelists, and we'll get going.
First, let me just say, Emily, thank you so much for being our inaugural leader and longtime inspirer in HLS Beyond. I think there are now QR codes liberally sprinkled. I can't say that they're all from us, but most are. And feel free to follow them and learn more about the program and the kinds of events we do. So thank you. And thank you all for coming. We know you have a choice of lunches, and we're pleased to know that you spend them with us. At least at a superficial level, law school teaches us to rise to speak with confidence and clarity. And of course, as a classic lawyer might have it, what you actually believe might be irrelevant. It's just making the argument. But there's also what people believe. And whether in the courtroom or in legal scholarship, there are times when we speak, we write, we say what we think. And other times when we reflect and decide that maybe we got something wrong, or facts changed and there was some exception to a rule that we thought was pretty firm. And at the heart of the scholarly and academic enterprise is the idea that when you find out you're wrong, at least in theory, you should be really happy because now you have a chance to align closer to whatever the truth is until you change your mind again. So in that spirit, we thought it would be interesting, and I think this is now our 4th year doing so, to ask some members of our faculty when, why, how they changed their minds about something, and were they lying then or are they lying now? I wanted to start with sort of seriatim each of our guests and put something on the table and then see where we might go from there. So if I might, Elizabeth Prelogar, General Prelogar, is it still General?
I still go by General if you're willing to call me it.
Yes, very good. General Prelogar. You achieved some celebrity because of the live webcasts of the court where people would get popcorn and sort of be cheering you on as the lead advocate for the United States of America, its people, its Constitution. And you're somebody who clerked for 2 justices, seriatim, which means you could make a kind of Chatham House rule characterization of a justice and we wouldn't know which one. And I'm curious, did you see processes, how frequent was it, where justices changed their mind from the first time you got a sense of things to the time an opinion came out the door?
So that's a great question, and I don't think there's a universal rule or formula, but I think in many cases the justices go on the bench, which is the first time as a law clerk that you're seeing all of them together, and their first opportunity to kind of take the temperature of their colleagues and get a little bit of a sense of where everyone stands on the issue. By the time they take the bench, they've read into the case, they've obviously looked at the parties' briefs, they formulated their ideas for oral argument, and I think they come in usually with an instinct of how they're going to vote in the case. And then the question becomes, and what I sometimes get asked is, can oral argument change anything? And the answer is, it depends a little bit on how deep their instincts run and how closely they've kind of formulated their thinking on the case. I do think there's a lot of room for them to change their mind about how broad or narrow the court's decision should be, what the principal basis of the court's decision should be. A lot of times in that oral argument, they're hearing not only from the advocate, but hearing concerns or issues placed on the table by their colleagues, and that can sometimes affect their thinking. And so I'm a big believer in the idea that oral arguments matter, which is maybe what I tell myself as an oral advocate. But I do think there's a lot to the idea that there is room for the justices and decisional space for them to come at argument with a way of thinking about it and have that way of thinking altered. And then there's the whole process of writing the decisions and circulating drafts behind the scenes, and there's room to change minds there. You know, I am not going to name names or cases, but I saw firsthand the actual majority flip to a dissent or vice versa. In particular cases, it's rare, but it happens, where through the process of writing and circulating those decisions, a justice, a key justice, it would always be a 5-4 decision, might change his or her mind, and that could actually change the result.
And last question about this process before turning to the topic on which you changed your mind. It's a highly stylized process by which a court, and the Supreme Court in particular, encounters a case, comes to that instinct, debates or not with one another, sometimes through the course of oral argument, and then, as you say, through the process of writing an opinion. Is there any, if you were not just general but chief, is there any change you would look to that very stylized process to possibly encourage more reflective thinking and maybe more changes of mind if that were a desirable thing?
So if I were chief and the ruler of the Supreme Court, if not the universe, then I think what I would most want to do is to give an opportunity to have a more complete oral presentation of the issues. And the court has already changed this a little bit with recent changes to its oral argument structure and format. In the old days, the court would have 30 minutes per side and stuck to it with no exceptions. It was the kind of thing where if your red light went on and you were mid-sentence, you sometimes had to stop right there or make sure that the rest of the sentence was only a couple additional words. But during COVID, the court switched to a format where they took seriatim time for each justice to go in order of seniority and be able to put questions on the table. And when they came back from COVID, they combined those two approaches. So now, if you've listened to oral arguments, they actually go much longer because you still have the first 30 minutes, which is a give and take, a back and forth, a free-for-all, and then you have protected time for each justice to ask questions, and that's not time limited. Sometimes it goes very quickly. Justices take a pass. They don't have questions. Sometimes, I think my longest argument, I was at the podium for well over an hour. So that gives an opportunity for a more complete debate and for everyone to have time to participate in that decisional process. If I were chief and could tweak it even further, you know, the court has very rarely ordered re-argument in a case. It doesn't happen very often, and there's probably good reason for that. The court wants to wrap up its work in a term and be able to turn to yet an additional set of issues in the next term. But I think that there are sometimes circumstances where an issue comes up and takes on greater prominence for the first time at the oral argument, or where the justices, when they're circulating those draft decisions, really begin to grapple with something that tends to be more difficult or that hadn't been the focus of attention before. And I think the court could think about more readily ordering re-argument in those circumstances to, again, get everyone back in the room and to be able to flesh out in the moment how the thinking has evolved.
Amazing to think that something like the affordances of Zoom changed permanently that process. It's funny to think of the justices on a Saturday night saying, you know, let's just get everybody together on Zoom to get that one last question down.
They're old school, so it's definitely a dial-in.
Yeah, very good. One that rarely works. So, all right, well, thank you for that insight. On to something on which you have changed your mind.
So I'm going to confess something at the outset. I'm going to talk today about the propriety of universal remedies. And a couple of days ago, I was talking to a friend and mentioned that I was doing this panel, and she said, "What are you going to talk about?" And I told her that. She's not a lawyer. And she gave me this look. She didn't quite say, "That sounds super boring," but I could see it in her eyes. But I assure you, if you bear with me, I think that this is actually a fascinating legal topic and one on which a lot of people have evolving thoughts, me included. So my views on this and the way that my thinking has continued to evolve really arise from the different hats I've worn over the course of my career. I have spent time in the private sector on multiple occasions, and I've spent time in the government on multiple occasions. And so I have come at this issue from both sides of the V, sometimes as a government lawyer and sometimes as a lawyer who's representing a private litigant who's suing the government. And I first got my start at a law firm where we had clients who were sometimes taking on the government. Let's say it's a client who thought that a recent final rule issued by an administrative agency was unlawful. Maybe it presented a constitutional problem, or maybe it wasn't authorized by statute. Sometimes it was representing a client in a pro bono case who was pursuing impact litigation, who thought that a government executive order, a policy, a state law was unconstitutional and created concrete harm to civil rights, civil liberties, or otherwise. In those contexts, the initial goal always was to secure relief for the client. We wanted to be able to ensure that the client would be protected and have a remedy. But we also very much welcomed broader relief, and that made sense to me. The idea of getting a universal preliminary injunction or getting an agency rule vacated made sense because we had just gone out and established in district court that that was invalid, that by definition, if we're getting remedies, it's because we've established the predicate legal violation. And my view was, if our arguments equally applied elsewhere, if this state law was unconstitutional, then there was something unjust about the state being able to go out the very next day and enforce that law against someone else. So we welcomed the idea of a preliminary injunction that might apply throughout the entire state, or action that would operate directly upon the agency's rule and would vacate it and mean that the agency couldn't take steps under that rule with respect to anyone. But then you fast forward a few years, and I was now working for the government. This is a remedial question that always operates to the government's disadvantage, because in a circumstance where universal remedies are being entered against the government, it stymies the enforcement efforts against anyone, and if it's nationwide, anywhere. And from that perspective, my thinking began to evolve a lot. I obviously had a different client, and I was coming at it with a different set of goals and litigation, but I also began to see some of the legal and practical problems that can arise from this type of universal remedy. On the law side of things, there are real substantial questions about the authority of courts, Article III courts, who have limited jurisdiction, to enter relief that extends beyond people who aren't parties to the suit. So long as there's a narrower remedy available, if you can take action that will grant the plaintiff, the party who's affected in the actual case or controversy, a full remedy, then the argument would be that maybe Article III doesn't empower you to go further. And there are also arguments in the context of agency regulations, APA litigation, under the APA, that maybe vacatur shouldn't be a default remedy or isn't actually authorized by Congress in the first place. So I began to see that actually, from the legal side of things, this was a pretty nuanced question, and there was a lot of work to do to try to think through history, practice, text when it came to the statute, the APA, equitable authority, background principles, and otherwise. So that was the law piece of it. But then there was also a real practical issue that arose if you are the government and you're suddenly facing a nationwide injunction. And the practical issue is this. Suddenly, you've taken an adverse decision and wildly magnified its effects. It turns it into a much bigger deal if the government is enjoined from enforcing the policy anywhere. And particularly in a situation where you're the government and you think the district court got it wrong and actually the policy is valid, that turns into a pretty substantial intrusion on the executive branch prerogatives.
Do you have a favorite example, a concrete example where it just seemed really outlandish to have a nationwide?
So one example that readily comes to mind was the student loan forgiveness plan that was announced through the Department of Education and was a signature policy of President Biden to try to redress the financial hardship that so many borrowers, student loan borrowers, found themselves in after the COVID pandemic and its aftermath. In that litigation, there were various permutations of it, but in one of the suits, there were a handful of individuals who had student loans, and they had sued because they said they didn't want their loans forgiven. And the reason that they didn't want their loans forgiven, according to their lawsuit, was because they thought they might be able to get a better deal or have greater eligibility if it wasn't this particular student loan program, but if instead the Department of Education proceeded against a different authority. But what they claimed was a remedy that no one's loans could be forgiven. And, it seemed to me like the obvious way to fix that injury, if there's an injury, we thought the program was valid, so we didn't think that they actually had a legal argument to stand on. But it seemed like the natural way to fix their injury would be to just not forgive their loans. And then those people could continue to pursue.
Could the government have just offered a settlement there?
So the government said
Said
there was an
we're
opt-out. There was no...
perfectly pleased to keep taking your loan payments?
Yes.
I mean,
And in
you want it,
fact-
yeah.
In fact, that was the argument that was made in lower court, that, ultimately these people, their loans would not be forgiven.
I'm
They
just
could
wondering
opt
why
out
you
of the
didn't fail
program.
to forgive them and then moot the case.
Well, sadly, a court in Texas disagreed that that was a viable option and said, nope, this is an unlawful policy, and so therefore we're not going to allow any students' loans to be forgiven anywhere in the nation. It wasn't a litigation choice by the government.
Got it.
Can we ask each other a question?
Absolutely.
I'm just really curious since you're so interested in talking about the different roles, can you think of an example where you think the universal injunction approach is wrong, where you would have liked the result of it?
Wow, I mean that's
We're getting those every day. We're getting
going
those every
like
day now.
3 levels deep now. Well, actually, this is an important point. I'll have to think about a specific example, but one of the points I want to make here is that I think one of the reasons people's views on this shift is because it depends in part on whose ox is being gored. If you, the reason why when I was in private practice I thought universal injunctions, it made sense. It was the just result, was because I believed strongly those policies were invalid. When I was in the government and I thought that we were defending lawful government work, then it seemed like a real problem.
But so the test of it really would be if there were a flip.
Exactly,
And is
exactly.
there?
And where I think, as a litigant, I think you can see how you might argue on both sides of the issue, but I think for courts, that's where it really comes into play, because with courts, I think what they need to do at the outset is come up with neutral principles to guide their thoughts about remedies, and then apply those neutral principles regardless of the particular policy they're considering or what president happens to be in power. But the problem on the government side, too, was that it created real asymmetries, because, if you get faced with a nationwide injunction, then suddenly you're disempowered from being able to enforce that policy anywhere. It also means that you have to run the table. You could win in case after case after case, and then one bad result and one nationwide injunction, it undoes all of the
Until
prior
there's appellate
litigation
review
success.
or one imagines the Supreme Court tries to.
Well, and that is kind of the final piece of the puzzle here. I also began to see the link between the rise in universal remedies on the one hand, which has been a relatively recent phenomenon, and the use of the court's emergency docket on the other hand. This is something that's been very much subject to public attention, the rise of the court in emergency cases weighing in on a dispute early on. And when I was the SG and I'm the government lawyer, I would go to the court in contexts where I thought we could make the showing. But the reason why we could sometimes make that showing was because when you are enjoined nationwide or when the agency's rule is vacated universally, suddenly you might have the kind of irreparable harm showing you wouldn't have otherwise, and you might be able to establish it more as an emergency situation. Now, I'll say, when I was in the government, we staked out a pretty bright line position on this. The legal arguments I flagged earlier under Article 3, under the APA, we pressed, at least as a frontline argument, as bright line rules, that this is just a kind of remedy that's never authorized. But I think that, now that I'm outside government again, I'm not wearing that hat. My role is not to represent the government's interests. I do think a lot about whether it has to be more nuanced than that, and whether when you really dig into the legal question, there have to be contexts where maybe a more universal remedy is necessary to actually redress the particular party's harm, or maybe there are case-specific factors that would demonstrate that that's an appropriate exercise of the court's authority. So my thinking on this, I still haven't made up my mind. My thinking on it continues to evolve.
It's amazing that how much where you stand depends on where you sit, and where you make up your mind may depend on your next job. But one last question before we move on. Under the Article 3 argument you talked about, that's less about district courts sitting in name your tiny jurisdiction. That's about Article 3 courts. Yeah. So by that logic, would it mean that the Supreme Court, which I gather only it now colloquially, not really, strikes down a law, it's not excised from the book, does that mean even once it goes all the way up and down the pachinko machine and the Supreme Court weighs in, it still only binds the litigants?
I think the answer to that, if you buy into the idea that Article 3 prohibits it, is that Legally, yes, but because of the court's role in our society, once it has definitively resolved the legal issue, then that serves as precedent in all future cases. And so, although the particular judgment in the case would be party-specific, the fact that the Supreme Court has said this law is unconstitutional means that it couldn't be enforced without, defying the court's articulation of what the law requires. And if, in fact, the executive nevertheless went ahead and enforced an unconstitutional law, the right result would be to rush back into district court
with a new plaintiff and
plaintiff.
non-mutual issue preclusion, which I never thought I'd have to think about again.
Assuming that plaintiff hadn't yet been put on a plane to El Salvador.
For example. I was just about to move along, but now it sounds like that's why I'm moving along, but I'm just moving along. We'll have time for general discussion throughout. Lucy White, you've been thinking about so many topics over your career. So curious what you've changed your mind on.
I'm just thinking now about what the Judiciary Committee is trying to do with respect to the issue that you're talking about.
The House just passed something yesterday.
Congress too, and I'm kind of looking at that and thinking, where were you, Congress, when I was SG?
Exactly.
Yeah.
Well, what I was thinking about for this, it's a huge change of mind for me. And that is for many years, I worked here in the US, a lot of the time in Cambridge, working with community groups to help them feel stronger, feel more full of their power, feel more savvy about strategies, feel more capable of handling injustices that they perceived, with guidance from me and people that I worked with, but it tended to be a very light kind of guidance, and it was more kind of getting behind where they wanted to go. And that work was very much informed by some teachers of mine, someone you might, those of you who do legal aid type work may have heard of Paulo Freire, a great Brazilian lawyer, educator. Another person, Miles Horton, who did a lot of thinking about this. Jennifer Gordon, who created the workplace idea, really had the sense that you could work with groups this way and bring out their sense of power and their sense of strategic savvy. I was so into this. I worked all over the place in Cambridge. I spent years in a clinic with low-income women who got it together to storm the State House to get Medicaid, dental Medicaid for their kids, and I could go on, everything. And you could just feel these folks gaining power and gaining the smarts together to figure out these very complex playing fields. So I thought, how could I ever change my mind when I'm totally not just committed to this, but I can feel it in my bones. And there's a theory behind it. Okay, so then, actually about 25 years ago now, so I'm a real veteran of this stuff, I started working in Ghana in West Africa with struggling farmers, and a colleague of mine for many years who's now the dean of the university there, law school with students in Ghana, and I had students from the US and NGOs, and we began working on different topics with folks in rural areas in Ghana. And of course, I, surprise, surprise, was confronted by a very complex situation for me, where small spatial settings were just fragmented with all kinds of differences, often very fractious, colonial histories, multiple hierarchies, gender issues because women did all the labor, issues around land struggle, and you could go on. And people were really up in arms about it. Also, there was no opportunity for people to come together to do this, whatever we thought we were doing in Cambridge. And the other thing is the issues we were trying to work on were just too challenging for people to come together and magically be savvy and, solve the problem, get dental insurance for their kids or something like that. So that was the first moment that I realized that I had been naive. And when I thought back, I realized how naive I'd been back in the US because I had been totally blind to all the fractures and exclusions and everything, even in the most cohesive project that I'd ever worked on. This project in this health clinic in East Cambridge where I thought, oh, these people are just so, fuzzy together and whatnot. But I realized how naive and blind I'd been here because of that experience. So that was just the start. And then, as I thought more, I had thought that in the US it was so easy to bring people together because there were discrete issues they were fighting for, and these welfare issues. And if they didn't get relief by storming the State House, they could always go to court. It's very different than trying to get the crops to grow in Ghana. But again, as I reflected from being in Ghana on the issues in Cambridge, I realized that when I was working here, this welfare state that I thought was a focus of advocacy was actually falling apart while we were working there. It was falling apart, it was fracturing, and we were blind to that. So nobody working, the women I was working with, myself, no one from here, no one, was kind of up to speed to recognize that the folks who were trying to fragment and erode the welfare state were 10 steps ahead of us and 100 steps ahead of us. So I realized that this myth of being so savvy because you're empowered was just that. The other thing, of course, now, tragically, is you realize that just because a community is empowered doesn't mean that it's going to do things that are normatively good. And we're seeing that all over the place now, where groups are, quote unquote, empowered. They're lured to do actions together that are violent, xenophobic. You can name many names. There's a right populist movement throughout the world that is often supported by the grassroots. So with all those reasons, I really did a mea culpa and turned upside down with respect to community as the kind of shield I could put myself behind.
Yeah. Well, it shares, I think, with the first tale, a desire to represent clients, to make a difference, and to identify in some way an adversary or a challenge and to pursue it. The kind of work you're describing sounds like isn't just clear-cut litigation where exactly you know who the plaintiffs are and what relief for them is. And if I'm hearing you right, you're saying that your initial picture was you were bringing a certain skill set and access to levers of power to people that had neither of those.
Right.
And that you figured you were empowering them by being in the room and having good conversations, and then together, leading from behind, you were off to make a change.
Exactly.
And that the first sort of challenge to that was problems that are really diffuse and big, a group of clients or people you're trying to serve who may not have agreement with one another, so it's hard to say exactly how to empower them, and then that puts you more in a trustee kind of model where you're acting on what you think the modal hypothetical beneficiary would want. And then it sounds like the final step you're talking about is doubting your own ability to make change and skill because you feel the system itself sort of fragmenting or diffusing around you. And that then seems different. There seems no motivated reasoning here. You would have every reason to be like, I'm great, I was great then, I'm great now. But it sounds like you're landing in a place that was like, I don't know, look upon my works, ye mighty, in despair.
Yeah.
Is there?
Yeah, I actually have moved beyond despair, as a matter of fact. I'm moving slowly, but I'm really, from that experience, took away some understandings that are really guiding me now. I mean, the first thing is I really feel like I was naive, that I am much more interested now in political economy and a kind of deep mapping of the forces, legal, political, other social forces that are producing over time these issues, bringing folks together, whether they be experts or people with experience or whatever, not just people who have lived experience, to really think about the issues and design interventions that are iterative and tentative. You try them based on some kind of hypothesis.
Got it.
Once you try them, you step back and critique them, try something again, and that seems to me, right now where I am, that seems to me the way to go.
Very interesting, and it sounds like that political economy-centric view may presume that the forces that produce regulatory or other shaping results are themselves maybe not open to changing their minds so much. They only have changed incentives. But interesting to see your evolution of thinking on that. Questions for Lucy on this much before we hear Noah's tale?
I would just love to get your perspective. You mentioned recent events. You mentioned how sometimes empowering can actually lead to violence or results that we might not want. How do you draw the line? Because obviously, for marginalized communities, empowering them, grassroots organizing has always been an important part of the conversation and the important part of getting results. And so to what extent do you think that that needs to continue, but within the background concern about what results might look like?
I feel that for me, that bringing folks who are, and I think very much about stakeholders from different perspectives, not just people in communities that are there because you think they're special in some fashion, but stakeholders from different perspectives to really think deeply about a particular issue that's affecting them and think normatively, embrace the normativity and not pretend that it's not there. And as long as you have a group that's working together, you can raise iteratively the question of normativity. Mm-hmm. But I think what happens and what had happened in this community-based empowerment was the normativity was just put off the table. Mm. And, I think that's wrong.
Got it. Thank you. Noah, over to you.
So I've been thinking hard, trying to take this assignment seriously, about why it's so hard for lawyers in particular to say that we were wrong about something. And some of that's training, right? We're trained to reconcile apparently contradictory things, so you think to yourself, oh, I changed my mind, but there was actually a reason. It's part of the training. Part of it is self-selection. Probably we're all the kind of people who became lawyers in part because we never wanted to admit we were wrong. So there's some component of that too. And there are two kind of great legal invocations of this principle. There's one by a common law judge called Baron Bramwell, who had to change his mind between two cases in the 19th century, and he said, "The matter does not appear to me now as it appears to have appeared to me then," which I think is pretty good. But Justice Souter, when he somewhat famously flipped his view about how much evidence of externalities, third-party harms, a city would have to introduce before it could ban nude dancing, quoted instead, he cited Justice Jackson quoting Samuel Johnson, and on the asking why you changed your mind, and he said, "Ignorance, sir, ignorance," which I think is I think a good clue, and I'm going to try to focus on that, because if you look back at the past and you see something where had you had all the facts, you would have made a different judgment, and now you have the facts, and now you make a different judgment. That's a very easy mistake to admit. And in fact, you know, the justices like to use that if they ever have to overturn precedent. They don't do it as much nowadays. But at one time when they were embarrassed by doing that, they would try to come up with some explanation about how the facts had changed or new facts had come to light. Because that's a pretty good reason. You know, and I think there's some adage about that too, right? I mean, if you give me new facts, I change my mind. What do you do, sir? So that's one kind of change. But I really wanted to come up with an example of something where I had all the facts and I was wrong, and so I tried to change my mind in light of having the facts. And when Professor Zurchang was asking me to do this, I said, well, do you want personal or do you want legal? And at first he said personal is better, so then I gave him some personal examples, and he was like, no, those are bad.
I changed
I'm going
my
with the
mind.
legal example.
There were new facts.
So I'm going to go with I go with a legal example, and you're not going to hear from me about why I changed my mind about thinking that having good taste was the most important thing a person could have. I'm going to
There'll be a bonus director's cut of this with that.
Instead, I'm going to talk about modern legal conservatism, which I will sum up in what I sometimes call the Scalian trinity, which is judicial restraint, textualism, and originalism. And as this worldview, jurisprudential view, but also worldview, was sort of consolidating as I was a law student and then a young law professor, I was not just against this point of view, but I thought that this point of view was sincerely held by many people who magically always were using it to get exactly the results that they wanted. And the reason that I was strongly opposed to that was that the view they were opposing themselves to was, call it legal interpretivism, or call it, Warren Court liberalism, was a view that basically admitted that it was looking to outcomes when it came up with this jurisprudential theory. The jurisprudential theory entailed the idea, Ronald Dworkin says this most explicitly, that first you make your moral analysis, and then you interpret the legal materials in light of that analysis. And since the modern legal conservative view was intended to be a refutation of that view, it seemed important to me that it be able to reach outcomes that it didn't like.
And you would not hold the Warren Court to that standard?
Well, the reason they never did reach the conclusions they didn't like, but as Dworkin was sometimes accused of by critics of precisely this, why does your theory always give you the outcome that you want? To which he said, well, you've missed the point of my theory. It's not my theory requires me to consider the moral issues. And so, yeah, if I reach the exact opposite outcome of what morality requires, that was a bad legal decision. So for that reason, when a theory advocates for itself that it's okay, in fact, it's desirable, in fact, it's necessary to reach the morally right decision, it's not a great argument against it that it never reaches the morally wrong decision. But the other view was presenting itself, the modern legal conservative view was a view of constraint. It was supposed to be a view of constraint. And I was very troubled by the lack of constraint. And then from there, I went on to make substantive arguments about each little piece of it. Not so much the judicial restraint, but the textualism and the originalism. But in the end, I think what was really motivating my criticism was not just the internal arguments, but the idea that it's not constraining in real life. And then I added theoretical reasons for why that maybe was impossible for it to constrain. And I think that over the last several years, I've begun to think that I was wrong that this approach cannot constrain. And I should add, by the way, Bush v. Gore was a moment in my life which nobody much talks about now. When I inherited my casebook in constitutional law, Bush v. Gore wasn't in the casebook. So embarrassing to the structure of constitutional law, you just leave it out. But it was an example where all of the justices, all 9 of them, flipped in what their ordinary jurisprudential commitments should have been, and it looked very outcome-orienting, and it was very embarrassing from the standpoint of seeking consistency. And then the court put in, by the way, this isn't really a precedent, which is even more embarrassing. Okay, so why have I changed my mind about the capacity of modern legal conservatism to constrain? It's mostly because of watching a few of the justices. Right now I have Justice Barrett primarily in mind, and she's relevant here because I called that theory the Scalian Trinity, because Justice Scalia did more than anybody to formulate it, and she clerked for Justice Scalia and is a deeply committed devotee of the Scalian worldview. And watching her on the Supreme Court, I see her actively being constrained by the structure of these theories in the face of, say, history and tradition interpretations, which are a way around, in my view, a way around those approaches, around textualism, around originalism. So you can see her, for example, objecting to history and tradition analysis in Bruin by saying, well, wait a minute, which history are we using here? Is it relevant to the original meaning of the Constitution, or isn't it?
Bruin being the Second Amendment
The
case.
Second Amendment case. I see it as well in just some of the recent cases just this term, which they're all on the shadow docket, so who knows why anyone's saying anything exactly, and it's always a mistake to over-theorize. But I see her trying very hard to follow rule of law constraint principles that in her case are fully derivative of her commitment to textualism and originalism and to a form of judicial restraint as well. And to put this formulation in its most constraining, or most controversial form, you could say that the future of the rule of law in the United States right now depends on whether she and other Federalist Society endorsed justices are true to the Federalist Society principles as the Federalist Society wrote them and as the Federalist Society has, at least officially, continued to embrace them. I mean, there's a sub-question of what is the future of the Federalist Society. Well, I'll leave that to another day. But famously, President Trump outsourced a lot of his judge picking to the Federalist Society. And now the question is, will those Federalist Society judges be good Scalian Trinitarians? And if they are, they're gonna save the rule of law. And if they aren't, they're not. So where I've changed my mind is in thinking that these components of modern legal conservatism were not constraining. I see them now as having constraint on at least some of the justices in some of the biggest and most important cases in front of them. And I had the facts before, and I think that I was wrong in my thought that there was insufficient degree of constraint here. And I could be proven wrong again if it doesn't turn out the way that I'm hoping that it will. So there's maybe a little wishful thinking in my current view that I was wrong, and I acknowledge that, but I really hope that I'm right, that I was wrong before.
We'll see if it appears to you that it appeared wrong before. I maybe have 2 quick questions, and then colleagues, and then maybe we can open it up to everybody. The first question is, are you possibly underselling or oversimplifying what the Warren Court types were thinking? Because it sounds like something consistent with what you described their view to be was they get to decide everything totally impulsively. Every case presents a new thing. They look to see who looks like they need help more, or very grounded in the literal litigants and sort of the equities, and then they just ask the large language model to come up with the right words to make it all happen. Versus they have
So that's where the penumbras and emanations came from. Huh? You want to blame them on an AI?
I mean, we have a Ninth Amendment, but we digress. It could be that they are trying to integrate some moral view whether their own or what they see as a consensus moral view of the polity, which, as Lucy was saying, is an awfully hard thing to determine. And then they want to be consistent to that, and that might lead to individually regrettable results. The exclusionary rule, I mean, unless Justice Warren was like, thank God, another criminal on the street that we had dead to rights, but they forgot to say the magic words about you have the right to a lawyer, so off they go. That is an example, I think, maybe, of a regrettable result because of a particular remedy that they thought important against the great backdrop.
Thank you. Let me just say two things. As in both the case of the liberal position, constitutional position, call it living constitutionalism, and in the case of the Scalian conservatism, I'm taking as exemplary the most plausible, philosophically consistent defense of the practice. Okay, I'm not claiming it's always being used by all. We're all human beings, and no judge is completely perfect. When once in a while Justice Scalia would reach a result that didn't seem to make sense under Scalian principles, Justice Souter would raise his eyebrows privately and say, his is a complex jurisprudence. Which is kind of funny because you couldn't say that about yet a third position, a legal pragmatism. There's a legal pragmatist position that says, and I associate this with Robert Jackson, Justice O'Connor, and Justice Breyer, that says what you're actually supposed to do in every case is figure out pragmatically what the best thing to do is. And that can include a kind of rule pragmatism. But in the end, every rule is just made to be broken. And you see this in, Justice Breyer was always at the end of his career issuing opinions in, say, First Amendment saying, I don't like the doctrine. It's stupid. Can we just not use it? That's when you're in the presence of extreme pragmatism. But that's not what the liberal position was. The liberal position was, and I think Ronald Dworkin's formulation is the most attractive, was sure there's law, and law does some constraining. But in the really important cases, it doesn't constrain you that much. And actually, in the end, and at the end of his career, he admitted this, it maybe doesn't constrain you at all in the presence of really strong moral factors. But for sure, those moral factors could be rule-based sometimes, or they could be individually based. There's plenty of cases that the Warren Court decided, because they used to take 300-400 cases a year, where they were just deciding it on the equities, for sure. But I'm not trying to ascribe that view to all of it.
Got it. And second question, I wonder if you've formed a view about what might be described as a post-Scalian framework, which would be Adrian Vermeule's common good constitutionalism.
Yes. So Professor Vermeule, as maybe many of you, maybe some of you know, has had himself what I suppose is a change of mind, and I wish he were, we're here to talk about it. He has come out of the closet as a Dworkinian, and in his Common Good Constitutionalism Manifesto, he calls it a manifesto. It's not me calling it a manifesto. You never want to call someone else's work a manifesto unless they called it that first. It's not polite.
If you call it that, it's a Jeremiad.
Yeah, exactly. Someone should write something like that. This is a Jeremiad. He says, you know what, and he also clerked for Justice Scalia, he says, Dworkin was right all the time. It's all moral analysis. Dworkin just happened to be liberal and Kantian in the content of his morality, but that's the wrong morality. The right morality is natural law theory of a very specific medieval Catholic type, and that's what the courts should use to decide cases, and let's just be open about that. And he's incurred a lot of wrath from, among other things, the old school Federalist Society folks, who were like, this is literally 180 degrees the opposite of what we stand for. But that view is also extremely exciting to some young conservatives who think to themselves, this is a great theory for a world where we have 5 or 6 votes, because now we're not going to be constrained. So if the liberals weren't constrained, why shouldn't we be constrained? Plus which, if natural law is true, then it must be the right theory, which is also very Dworkinian. I mean, Dworkin's answer to Vermeule would have been, if Dworkin were still alive, well, you got half of the theory right, but you got it wrong fundamentally because you have the wrong moral values. And Dworkin believed that there were right and wrong moral answers. And he would have been very clear, I can say this on behalf of his shade, that Professor Vermeule is wrong about the substantive morality of many, many questions. So that is a very interesting approach. It's a form of view changing, and it's a convenient form of view changing seen in outcome determinative ways, but it's more sophisticated than just saying I flipped, because it's saying I flip to the view that it's right to follow what is morally right. And then you can kind of defend yourself against the criticism, the same way I was defending the Warren Court against this criticism, by saying, well, you just got the wrong end of the stick. Like, of course the morally right outcome is the justification for what I'm doing, because it's morally right. And what kind of a person thinks that the law should not give effect to what is morally right? Only some kind of a bad person.
Both General Preligar and Professor White seem to ground a lot of their change in view in their personal experiences. Certainly personal experiences intellectually arguing and processing a bunch of stuff, but it was where they stood or where they traveled and experiential sort of new facts, as it were. I'm curious, is yours an example less of that and more of just reading the opinions, seeing which way the wind was kind of blowing in society, and looking at the number of votes on the court?
No, I think I was dumber than that. I mean, I think my view was based on the idea that even if a theory sounds really good, it can't really be. I was sort of had a hermeneutics of suspicion, like as it's functioning as a whole. Even though I knew plenty of people who seemed to actually believe it, there were no cases, or almost no cases, standing for that proposition. And so I thought, maybe they don't really believe it deep down. And I just think I was wrong about that. I think it was a mistaken analysis. A case where experience changed my mind is, what I was going to say about taste. That was a kind of self-reflective process.
Yeah.
A kind of self-reflective process where I came to see, I won't say it, but where I came to see how I came to that view and realized there was something wrong with how I came to that view, and therefore that I was wrong.
We all want to hear the story now.
It's not any one story. It's just, anyway. Not going to cheat and do two.
No.
Lucy.
Yeah, I'm wondering, I struggle a lot with language because it really is, and I'm not talking about indeterminacy, I'm talking about, in its very nature, it's slippery. And how is your newfound theory consistent with just how language works? Kind of no matter how constrained you are, you still have to kind of weave your thinking through language.
Well, what I'm offering is a change of mind about whether people who profess legal positivism,
Right.
which depends on a certain theory of language,
Yeah.
whether they really believe it such that it would cause them to reach outcomes that I know for a fact they consider normatively incorrect in particular cases. And what I'm saying is, my theory of language could be consistent. I'm really interested in the underlying psychology of people who profess a certain theory of language, because legal positivism, namely the idea that law is rules and that we should follow those rules, that's an oversimplification, but that's what legal positivism is, really believe it. So, they could be wrong about the merits. It could be that Dworkin and Vermeule are correct and language just isn't susceptible of that, but that's independent of what I was wrong about.
Right. Well, once you switched to your right now, what kind of theory of language are you left with? That's what I'm trying to understand.
I truly can't answer in 30 seconds, but I would just say my 30-second version of it would be this. I think that the way that language functions in law is that it functions as the water in which we're swimming, and we can't swim without it, and we would not be able to do what we're doing without it, and so it offers some forms of constraint just by virtue of its properties, the way that water offers some constraint to how you can swim.
Right.
I love how the answer on language is metaphorical.
Yeah, no, but that's
There's no getting outside of language.
Yeah.
exactly.
There is no way getting out. Wittgenstein tried, it didn't
Words
work.
There are how much exactly you're back.
Yeah.
Yeah, you're back at square one in some ways.
Shall we open it up? And I think the UN-style mics might actually work. If they don't, I can scurry up. So, so please go ahead. Understand that we're recording. Feel free to say who you are or proceed to your question.
Hello, testing, yes. Hi, my name is Jasper. I'm a 2L.
People hearing?
Yeah,
Okay, great.
Okay. And
When
my
you push it, you don't have to hold on to it. It's supposed to just work. All right, okay.
and my question is, first of all, how do you go about approaching changing other people's minds? And as you do so, outside of an oral advocacy context, how do you leave yourself open to having your mind changed through that conversation?
I have a metaphor, which is that I think convincing people of something is like going shopping for clothes not online, like IRL shopping. The most you can do is get people to try something on, look at themselves in the mirror, and ask themselves, how do I look in this? And if they like how they look in it, then they might buy it, and it might be their idea. That's all you can do. You can't force it on them. You can just see if they'll try it on.
I think there's an element to it as well, though, of taking your time in trying to socialize the issue with the person you're trying to persuade. I spoke about the efforts when I was representing the government to convince the court that nationwide remedies, universal remedies were improper. You know, as a litigant like the United States, who's frequently in the court, you have a chance to have an ongoing dialogue. And so I always viewed the enterprise as starting the conversation, putting the arguments out there, getting the justices thinking about it. You know, I probably didn't expect to win. Certainly, in the first time we made those arguments, the government still hasn't won on that. The court has declined to take it on directly and consider it. But it's part of an ongoing dialogue to open up the aperture a little bit in terms of trying to persuade a group of decision makers over time and with the fullness of continued deliberation.
That's really interesting because I think in response to that question, I would say I kind of lapsed back into what before I changed my mind, which has to do with listening and trying to be open to the other position and trying to re-examine your own position in light of the other's position and still hold on to your normative foundation as you're reconsidering it.
Yeah, yeah. And I've got to say, something that seems maybe in common among many world-class sort of just exceptional advocates, present company included, is speaking to the best version of the adversary's argument rather than the easiest. To the extent you can actually build it up to be the hardest hill to climb and then try to climb that, rather than in little ways construing it always to one's own benefit and then attacking that. That feels a nice way of saying you're trying on their clothes and explaining why they still don't fit.
Yeah, and in terms of being open to changing your own mind, the most important thing, I think, is just realizing that lots of thoughtful, smart people think the opposite of what you think.
No.
And they can't all be badly motivated all the time. I mean, they could be, in theory, but they probably aren't. You know, and then just ask yourself, you know, beseech yourself in the bowels of Christ, consider that ye may be mistaken.
Yeah, that's the most important thing, I think.
Got it.
To consider that your own position can be shaky.
And to your point, Lucy, to listen, to be open to listening, to not immediately start thinking of your counter arguments and all the reasons why your adversary is wrong or the person who holds the opposing view from you is wrong, but instead to really listen to what they're saying and absorb it before you formulate your own counter views to the extent they remain
How
counter.
comfortable did you feel saying, gosh, I don't know?
A lot of times, and in part, the function of my role was not always to have my mind made up. You know, many times the United States was coming into Supreme Court cases as a party where we had staked out a position in the lower court. But even there, sometimes we would tell the court, confess error, and say we thought the lower court got it wrong. The government as a whole had changed its mind. And sometimes we were coming in only as an amicus, and that gave a wide decisional space to think, what is the right answer here? What's the right answer on the law, and what's best going to advance the interests of the United States? And so I felt very comfortable thinking, this is a hard issue. There are reasonable arguments on both sides. There almost always are when it's a Supreme Court case, because by definition, usually it's divided the lower courts, and you've had smart judges around the country grappling with a legal issue and coming to contrary results. So I was very open and very comfortable saying, my mind's not made up. This is a hard issue, and we've got to figure it out.
Got it. Way in the back.
Hi. So my question is about the connection between the personal and the political and our personal stories, and it is to Professor Feldman, because you described your change as not through the personal experience, more about the intellectual journey.
In that instance, yeah.
Yeah. And would you agree that also, there obviously between the beginning of the 2000s to now, there's a big political shift within the US, then borrowing on Professor White's analysis of political economy and structural analysis, one could say that the locus of arguments and what is the conflict shifted, and now the liberal argument is very much outside of the Supreme Court, or at least where the decisions are, and it is within the conservative line, and now it's between textualism and originalism, or types of them. And then if you have a presupposed moral ideas, you want to intervene in this place. Maybe this is not like a conscious thinking, but maybe this is like...
Yeah, I mean, I guess
agree
the way I would describe it is, it used to be the Dworkinian Warren Court position on the one hand, and then the conservative position on the other hand. Now the liberal position is dead. It doesn't matter for the moment at the Supreme Court. And what you have is a debate within conservatism, but now you have the Vermeulian option. You know, maybe it's not his theory precisely, but you have justices acting sort of as though it were. History and tradition is that. And so now you have a debate within legal conservatism between the old legal conservative position and the new legal conservative position, which is just the old liberal position reinvigorated. Right. Okay? And that's the fight that's being fought out. And what I'm talking about is the old conservative position and whether it will turn out to be constraining. And my new hopeful belief is that it is for at least some people, and that it will be.
If you believe in water.
Hi, thank you all so much for the really thoughtful stories. I'm Luke, I'm a 3L. I was wondering if the panelists could answer whether you think changing your mind and being seen to change your mind is kind of extra important in a moment of really deep division, especially when the cost of doing so might be heightened.
Did you all hear the question?
No.
But I guess my view is that, and this tracks with what I was saying in response to an earlier question, is that in times of deep division, it's more important than ever to keep talking to each other and to not silo into our own spaces surrounded only by people who think like us and people who agree with our worldview and people who are going to reinforce our belief systems. It seems like that is a surefire way for people to be driven further apart and for the country to remain even yet more divided. And so I think at the very least, there's an imperative to try to seek out other views, to try to understand them, to, as Professor Feldman said, not assume that everyone is acting in bad faith. Instead, to assume that people are coming to disagreements with a good faith belief system and to try to probe that and understand it. Not necessarily an imperative to change your own mind about the way you think, but I think the best way to try to deal with those divisions is to understand where the other side is coming from and then to look for whatever common ground might exist and whatever shared values exist and build off of that.
I would just say, where I'm now is that you don't randomly engage with individuals who aren't situated in time and space socioeconomically and in other ways, and you try to be sensitive to that as well as, the talking head. Because I think you can be more sensitive in terms of listening if you're aware of those issues. I know that just in my own experience, working with very distressed women and trying to understand and listen and engage and put myself in their position, I had to really do a lot of work before I could even begin to do the kind of thing you're talking about.
And I would just say yes. The answer is yes. In a time of polarization, everyone thinks I got to stick with my team. And now is not the time when I can show open-mindedness. And that is the prescription for as General Preligar said, getting worse and worse and worse and worse. We go from in a conversation here to we won't even talk to the other people because they're bad people, so why should we even talk to them? So yeah, it takes tremendous work and bravery. Work is the internal part to be able to be open-minded. And bravery is the part where you can say openly, yeah, I was wrong about this, and the other side that I'm in a war with, and it could be a well-justified war, might have a few points on its side, knowing that your team is going to be shut up, don't concede them anything in this moment. And in a liberal democracy, maybe in an actual war where people are shooting each other, you shouldn't do that. That's an interesting question. But in a war that is nominally within a democratic polity, yeah, that's the whole point. If we're not talking to each other, then the whole thing is going to collapse, deserves to collapse.
Thank you for coming together in fellowship today to think about these things. I love that we didn't have a proposition we were debating. It's really three different starting points that converged quite quickly and has left me with a lot to think about. So maybe the next title for the next one should be like, I'm not quite sure what I think about anything. On that note, please join me in thanking